Good evening all. I am requesting all dignitaries to please join to the dais. Good evening to all distinguished dignitaries, respected members of the bar, and my dear fellow mates. On behalf of the Kerala High Court Advocates Association and Samatha Law Society, I extend a warm welcome to all who are present here for continuing legal education program on legal regulation of hate speech. Is it possible? Is it desirable? The session will be graced by Hon'ble Justice A.K. Jayasankaran Nambiar, Judge, High Court of Kerala. Dr. Venkat Iyer will deliver the keynote address. Dr. Venkat Iyer is a barrister and academic based in Northern Ireland. He is the Director of Educational Partnerships and International Affairs, Ulster University, where he teaches media law, constitutional law, and business law. With over 45 years of legal practice, he served as Law Commissioner for Northern Ireland. Dr. Venkat Iyer is the author of a number of books and articles, and the editor of 2 journals, The Commonwealth Lawyer and The Round Table, Commonwealth Journal of International Affairs, both published from London. Now, I invite Advocate Piyush Kottam, President, Kerala High Court Advocate Association, to this program. Now, next I invite Advocate Vinay V, Vice President, Advocate Association, to deliver the welcome address.
Thank you. Advocate Piyush Kottam, President, Kerala High Court Advocate Association, who is presiding over this session. Honorable Dr. Justice A.K. Jayasankaran Nambiar, Honorable Judges of this Court, distinguished keynote speaker Dr. Venkat Iyer, Barrister at Law, Northern Ireland, learned senior advocates, law officers of the Union and State, and distinguished members of the Kerala High Court Advocate Association and Samatha Law Society, law students from various law colleges across the district, ladies and gentlemen. On behalf of the Kerala High Court Advocates Association and the Samatha Law Society, I extend a warm welcome to all of you to this continuing legal education program on the theme Legal Regulation of Hate Speech. Is it possible? Is it desirable? This is a subject of great constitutional importance and contemporary relevance. It lies at the difficult intersection of liberty, equality, dignity, public order, and democratic responsibility. On behalf of the association, I congratulate the Samatha Law Society, Senior Advocate M.R. Rajendran Nair and Senior Advocate M.R. Hairaj sir for taking the initiative to have this creative and thought-provoking session to the members of the bar. In India, the starting point is clear. Freedom of speech and expression is guaranteed under Article 19(1)(a) of the Constitution. But unlike some absolutist free speech models, our Constitution itself recognizes that this freedom is not unqualified. Article 19(2) permits reasonable restrictions in the interest of, among other things, public order, decency, morality, defamation, and in relation to contempt of court, incitement to an offense, and the sovereignty and integrity of country. While India regulates hate speech through 19(2) of the Constitution and provisions of criminal law, jurisdictions such as in Northern Ireland, which is part of the UK, rely on public order legislation and the European Human Rights Framework, whereas the Republic of Ireland, that is a separate sovereign state, addresses it through specific statutes like the Incitement to Hatred Act and like. The comparative perspective reminds us that democracies across the world are still searching for the right balance between protecting free speech and preventing harm. In India, to the best of my knowledge, there is no specific law enacted to curb hate speech as such, other than some provisions like we all know 153A in the erstwhile IPC, which which corresponds to section 196 of the Bharatiya Nyaya Sanhita. And we have Representations of People's Act 1951, wherein provisions prohibiting using hate speech or communal appeals during elections are there. Again, we have the Prevention of Atrocities Act, which protects marginalized communities from humiliating speech and other acts. And Information Technology, that is Intermediary Guidelines and Digital Media Ethics Code Rules 2021, which requires social media platforms to remove harmful and hateful content quickly. Some pertinent questions that may arise are, how does the law distinguish between unpopular speech and unlawful hate speech? How do we prevent majoritarian misuse of vague legal standards? How do we protect robust democratic disagreement while responding firmly to speech that incites hatred, exclusion, or violence? And perhaps most importantly, can law alone solve what is ultimately also a social, political, and moral problem? These are some of the questions relevant to the discussion on the possibility and desirability of regulating the hate speech. That is why today's discussion is so important. Hate speech regulation is not merely a matter of statutory drafting. It is a test of constitutional maturity. It requires courts, lawyers, scholars, and citizens to continuously negotiate the proper balance between liberty and restraint, dissent and harm, tolerance and accountability. While the topic is vast, today's sessions bring a wealth of practical wisdom that will undoubtedly illuminate our path. We are greatly honored by the presence of Honorable Dr. Justice A.K. Jayasankaran Nambiar, whose scholarship and judicial insight have enriched constitutional and public law discourses. His Lordship has always strived to cultivate and promote critical thought process among the lawyers and jurists alike. His Lordship's guidance and support to the CLE programs of the association is deeply appreciated. On behalf of the Kerala High Court Advocates Association and the Samatha Law Society, I wholeheartedly welcome Dr. Justice A.K. Jayasankaran Nambiar to this session. Thank you, sir. We are equally privileged to have Dr. Venkat Iyer, barrister at law, Northern Ireland, who will deliver the keynote address. Dr. Venkat Iyer is a distinguished barrister in practice for more than 4 decades in Northern Ireland. With expertise in mediation and a distinguished academician, he is a director of educational partnerships and international affairs at Ulster University, a teacher of media law, international constitutional law, and business law. He is also former law commissioner for Northern Ireland and an accomplished author and editor of respected international legal journals. He has authored numerous books and he is also the author of 2 journals, The Commonwealth Lawyer and The Round Table, Commonwealth Journal of International Affairs, both published from London. On behalf of the Kerala High Court Advocates Association and the Samatha Law Society, and on behalf of each and every one of you present, I welcome Dr. Venkat Iyer to this session. With his rich experience in comparative constitutionalism, media law, and public discourse, I am certain that Dr. Iyer's address will illuminate both the promise and the pitfalls of attempting to legally regulate hate speech. For the sake of formality, on behalf of all present, I wholeheartedly welcome Advocate P.U. Sekottam, President of KHCA, Kerala High Court Advocates Association, who is presiding over this intellectual session. His continued encouragement and wholehearted support is fueling the CLE program in the best interest of the members of our association. Sir, on behalf of this association, I wholeheartedly welcome you to the session. Thank you, sir. On behalf of the association and Samatha Law Society, I formally welcome Advocate Rekha Vasudevan, Secretary, Samatha Law Society, an active and vibrant lawyer practicing before this Hon'ble Court, who is proposing the vote of thanks to this session. The Honorable Judges, Shamsa Sar is of this court, and learned senior advocates are the greatest strength of the CLE, who consciously or unconsciously, directly or indirectly, have been imparting guidance to the young generation of lawyers practicing before this Hon'ble Court. We continue to learn from their court craft, scholarship, restraint, and commitment to constitutional values. On behalf of the Kerala High Court Advocates Association and Samatha Law Society, I respectfully welcome you all, sir. I welcome the law officers of the Union and State who are present for this session, the law students from various law colleges across the district who have joined us in this session. On behalf of the Kerala High Court Advocates Association and Samatha Law Society, I welcome all of you. I welcome each and every esteemed members of our association and the Samatha Law Society to this session. And let me also remind you on the online platform, which we are already screening this program online in our YouTube channel. Almost thousands of members have joined us, and I'm also extending this welcome to all of you who are joining us online. May today's deliberation deepen our understanding and strengthen our commitment to the constitutional culture that protects both freedom and human dignity. Thank you.
Thank you, sir, for your warm welcome. Next, I invite Advocate P.S. Kottam, President, Kerala High Court Advocates Association, to deliver the presidential address.
Justice Dr. A.K. Jayasankaran Nambiar, Dr. Venkat Iyer, Barrister, Northern Ireland, Advocate Vinay, Advocate Rekha Vasudevan, senior lawyers, and my dear friends. We, our association, visualized continuing legal education program for enlightening, uplifting our junior members. But I don't know why there is shortage of members participating in this function. The junior members ought to have availed such a this opportunity for getting equipped by themselves. But unfortunately, today there is some shortfall. Today we are lucky to get Dr. Venkat Iyer, a great renowned speaker, and he is speaking on the subject legal regulation of hate speech. Is it possible? Is it desirable? I know all of you are eagerly waiting for listening to him, so I'm not spoiling even a single moment. Thank you to all. Let us have a good listeners of Dr. Venkat Iyer. Thank you. Thank you all.
Thank you, sir. Now it's my privilege to invite Hon'ble Justice A.K. Jayasankaran Nambiar to share the introductory remarks and set the tone for today's discussion.
Advocate Pius, President of the Kerala High Court Advocate Association, Dr. Venkat Iyer, today's keynote speaker, my good friends in the legal fraternity, brother Judge Sham. I must begin by congratulating both the High Court Advocate Association as well as the Samatha Law Society for putting together this program. I would have been much happier if I had seen a greater crowd of young lawyers. And I say this because I think it is necessary for us to have these discussions and deliberations on subjects or topics of contemporary relevance. As a civilization, our country, India, has always been known for its propensity, its desire for having arguments and discussions. It was something that was documented ages ago throughout civilization, throughout history. And there is an interesting book by Amartya Sen, the Nobel laureate. He titles it Argumentative Indian. And if you read that, you find that this capacity of ours to engage in deliberations and discussions on almost every topic of relevance is what has seen us through these ages and has seen our country develop in a principled manner throughout history. I say this is important because if you look around you today, what you find in society is complete intolerance. And intolerance is nothing but a lack of understanding of the other perspective in society. Intolerance stems out of a refusal on the part of a person or an individual to understand another possible perspective of an issue in society. The subject that we are going to be discussing here today is just another manifestation of that intolerance in society, hate speech. When we come to the aspect of hate speech, if you look for a definition of hate speech, you won't find one. It's not there in the Constitution. It's a concept, it's an idea. But what does our Constitution say about speech? You all know the constitutional scheme. There is a fundamental freedom, the right to freedom of, the freedom of speech and expression under Article 19(1)(a). It is a concept that is zealously guarded by our Constitution, so much so that you do not permit it to be restricted or infringed except under very limited circumstances. Those are the reasonable restrictions that you find in Article 19(2). And 19(2) elaborates on the reasonable restrictions that you can impose in the interests of inter alia, the integrity of India, and the interests of the relationship with foreign states, in the interests of morality, in the interests of defamation, speech that is intended to incite violence is restricted, so on. The important thing to note there is that in a recent judgment of a constitution bench in Kaushal Kishore in 2023, the Supreme Court went on to place the fundamental right at a high pedestal and say that when it comes to the reasonable restrictions that you impose under Article 19(2), you cannot go beyond what is already specified therein. In other words, you cannot add to the grounds already mentioned, expressly mentioned under Article 19(2). So this puts a limitation on the restrictions that you can put to free speech. Now that shows indirectly that speech is otherwise permissible, save in those exceptional cases which are covered by 19(2). And secondly, 19(2) itself should be read strictly so as to empower or so as to enable free speech to the maximum. So that's the constitutional scheme. And we give a great premium to free speech. And the reason is because in any democracy, you need to have a free marketplace of ideas. A society is generally known as a place where you have a marketplace of ideas. Sharing of ideas. It may be good for you, what you may perceive as a bad idea. You're obliged to at least listen to it, consider it, and then you can discard it if you don't like it. But the key is that you must enable somebody else to voice their ideas. And that's the essence of free speech that we talk about in this country. So how have we understood this concept of free speech in our country from 1950 till now? Well, till 2017, when the Law Commission actually the 267th Law Commission actually went into the issue of whether or not we should expand the concepts in Article 19(2). When it came to speech that had the propensity to incite violence, we read it rather strictly, and we said that when it comes to free speech, you can have free speech, you can express your opinions, you can express your voice, but it is only such speech as actually incites violence that is prevented or prohibited. That amounts to a reasonable restriction is what we understood. But by 2017, the Law Commission went into the law as it then was. It went into the realities in society and found that there was a necessity to expand that term a little bit so that we move from a mere incitement to violence to cover cases including speech that had the tendency to bring about a marginalization of either sections of society or individuals in society. Even that, according to the Law Commission, had to be roped in to the ambit of incitement to violence. So it is not mere incitement to violence stricto sensu, but it was also speech that had the tendency to bring about a marginalization in society. So this expanded meaning had to be given effect to, because it was the Law Commission's recommendations. Until then, we had only the provisions in the IPC which made criminal, which criminalized such speech as would incite violence. So the old provisions of the IPC, 153C, 153B, etc. But when the Law Commission made this suggestion, it was what one would expect was that this would translate into an amendment of the Indian Penal Code. It did not happen immediately. What did happen, though, was that the Supreme Court in two cases, in 2022 and 2023, read in or took note of this recommendation of the Law Commission and said that in those cases where there was speech that had the propensity or had the effect of bringing about a marginalization in society, the state government concerned was obliged to register suo motu FIRs and proceed against those persons. The first case was in Shaheen Abdullah in 2022, and we had two very erudite judges of the Supreme Court, one our own, Justice K.M. Joseph and Justice Nagaratna. But in Shaheen Abdullah, the directions were confined only to the states of Uttar Pradesh, Uttarakhand and New Delhi, not the other states. And therefore, the logical extension was felt in the next case that came before the Supreme Court, which was the case of, I think it was Ashwini Upadhyay in 2023. And the Supreme Court extended the directions that given in Shaheen Abdullah to all states in the country. So with that, you had a kind of judicial enforcement of the recommendations that were mentioned in the 267th Law Commission report. But then in 2023, you also had two different things happening. One, the Constitution Bench judgment in Kaushal Kishore, and then you also had the new set of criminal laws in our country. The IPC now came to be replaced by another penal code with a rather difficult name, the BNS. The content was more or less the same, but the suggestions of the Law Commission were probably found expression in the new provisions under the BNS. So now you have the BNS, which contains these clauses which criminalize acts or speech which has the propensity to bring about a marginalization in society. But that's where the catch is. Because if you look at the judgment in Kaushal Kishore, it says very clearly, as I said earlier, you cannot add to the restrictions, reasonable restrictions that are spelt out under Article 19.2. And then it went on to say something more important, the majority judgment. It said, while you cannot add to the express restrictions in 19.2, you cannot bring in concepts like dignity of an individual, etc., into the scope of the restrictions. In other words, you cannot say that in the interests of dignity, in the interest of protecting the dignity of an individual or a section of society or a class of persons, a reasonable restriction can be imposed. Now, where does that leave us? On the one hand, you have the criminalization provisions expanded to take in even cases of marginalization or offending the dignity of an individual. But on the other hand, there is a pronouncement by the Supreme Court, a declaration of law by the Supreme Court, clarifying the scope and ambit of Article 19(1)(a) of the Constitution, saying that it extends even to the free speech can extend even to making statements which may have the effect of marginalizing communities. So after Kaushal Kishore and the amended provisions of the BNS, you have a slight lack of sync between the constitutional law on the one hand and the penal law on the other. And why this matters is because when it comes to a conflict between the two, the constitutional right must prevail. So you cannot curtail a constitutional right by a statutory provision, even if it amounts to criminalizing such speech. So what's the way out? Because we are presently in this conundrum. The view expressed in Kaushal Kishore has since been affirmed through a number of judgments, the latest being, I think it was the Imran, what was it? Imran, that comedian's case in 2026. I think it's reported as late as in the last Supreme Court cases. There also the Supreme Court reiterated, it's a two-judge bench, but it reiterated what the Constitution bench said. I don't think it had a choice, but it had to just reiterate it. But what I feel is that the key, which is more relevant for the topic of today, is it desirable to have a regulation of hate speech? And even if it is desirable, is it possible legally? I think the key to that question, or the answer to that question, would lie in the dissenting or partly dissenting judgment of Justice Nagaratna in Kaushal Kishore itself. Because she devised a very innovative way of getting over the rigor of the majority judgment in Kaushal Kishore. What she said was very simple. She said that do not see these restrictions that you're imposing as reasonable restrictions on the right, or on the fundamental right under 19(1)(a). If you have speech that answers to the description of those offenses under the BNS, use it for the purposes of controlling or restricting or reducing the ambit and scope of the fundamental right itself. In other words, don't see yourself as having an absolute fundamental right of speech and expression subject to reasonable restrictions. You don't have an absolute fundamental right. You have a fundamental right only to the extent that it does not offend the criminal provisions. Something like your jurisprudential argument of your freedom stops where my nose begins. So that understanding, why it is important for today's discussion is, maybe the key to an effective regulation of hate speech lies in our internalization of the idea that whatever liberties and whatever freedoms our Constitution may have guaranteed to us, those freedoms come with an inherent restriction or inherent limitation which corresponds to our constitutional obligations to the fellow citizens. You have a chapter on fundamental duties. How many of us even look at it? We look only at fundamental rights. We don't consider fundamental duties. Harking back to an era when India, the ancient legal system, just imagine that we are a country which began a regulation, we had a first Indian legal system which was founded on the concept of dharma, which translates as duty. And for such a country, when we gave to ourselves the Constitution, we did not have a chapter on fundamental duties. We had only a chapter on fundamental rights, because that is what the British taught us. So the fundamental duties chapter comes in about 24 years later. That, I think the time has now come for us to realize that you can't have a fundamental right, you can't think of a fundamental right divorced of your fundamental duties. And therefore, ultimately, it's a question of balancing between the rights and duties. And think of it that way. If that is the understanding, if that is the idea that we can live with, then many things fall into place. Why? Because dignity of an individual, which has to also be protected, because after Puttasamy, dignity is read into Article 21 of the Constitution. Whenever you make a speech that has the propensity to affect the dignity of another individual, what you're effectively saying is, here is my fundamental right under Article 19(1)(a) coming into conflict with somebody else's fundamental right under Article 21. When two fundamental rights collide or come into conflict with each other, the normal test that you apply in law is that you prefer the fundamental right which advances the greater public good. One. The other way of looking at it is, you apply the proportionality test which you use in constitutional law and administrative law. You apply the proportionality, double proportionality test to see which of these conflicting fundamental rights should prevail, and reduce or limit or restrict your fundamental right expression to an extent which will permit both to coexist. So that understanding must come because of a self-regulation, because of an internalization of constitutional concepts by every individual in our society. When you do that, you're also adhering to a very, very important principle in our constitutional law, in our constitutional psyche, which is constitutional morality. And I suspect that it is this constitutional morality that is seen under Article 19(2) as a reasonable restriction that can be imposed on free speech in the interests of morality. When the Constitution says morality, it refers to constitutional morality. That is also laid down by the judgment in Puttasamy. So, and in the Sabarimala judgment also. So, when you talk about restrictions on free speech, ultimately it's a balancing of rights. And to answer the question that is posed for the discussion today, legal regulation of hate speech, is it possible? Is it desirable? It is both. And I think the way forward is not exactly through legal regulation, but a regulation by ourselves, a self-regulation on the principles of constitutional morality. That's my take on it's my perspective of the issue today. I'm so sorry if I've taken a little more time than what is normally customary for an introductory speech, but I thought I would just set the stage for the discussions to follow. I'm so eagerly waiting to hear Dr. Venkat Iyer and what he has to say on this. Thank you.
Thank you, my lord, for those insightful remarks. Without taking much time, I now invite Dr. Venkat Iyer to deliver the keynote address on the topic, Legal Regulation of Hate Speech. Is it possible? Is it desirable?
Thank you very much for all the kind remarks that many of you have made about my presence here, and I want in turn to discharge a very pleasant function, which is to thank a lot of people who have been instrumental in putting together this event. I'm not going to spend too much time doing that, but I still think I have to formally thank the Kerala High Court Advocates Association, its office bearers. I also want to thank, at a personal level, Hari Rajendran. Hari has been an exemplary host. I did not know him even 6 weeks ago, but he now has become a very firm friend, and I'm very grateful for his friendship. I want to thank the judge for not only his kind remarks about me, but also for agreeing to preside over this event. And of course, the office bearers. Now, as I was sitting listening to all of you, it occurred to me that my job has been done by the three of you. Because in different ways, you've actually adumbrated a number of points that I was planning to make, which actually is not a bad thing because it will save us some time, hopefully, for question and answers. So I'm told that it is possible to take questions. I'm perfectly happy to do it. I believe this event is being live streamed and also recorded. And I was very pleasantly surprised to hear from Rekha that some 3,000 people are online watching this event. So there is no need to despair over the lack of a full auditorium here. So what I will do is talk essentially about those aspects of the topic which have not been directly addressed by either the judge or by the office bearers. And I shall also give a viewpoint which is very congruent with what has already been said, but which has a slightly different dimension to this rather complex topic. The first thing to say is, if I were to speak in headline terms, the topic we have for discussion is legal regulation of hate speech. Is it possible? Is it desirable? My very short answers to those two questions is only up to a point for both. And I'll explain at some length why. I'm probably going to speak for about 40 minutes. Is that all right? And then leave some time for Q&A. Now, there is no doubt about the relevance of this topic. It's an extremely relevant topic because there is an increasingly heated discussion of the effects, both real and imagined, of hate speech. I put hate within inverted commas for reasons which will become clear to you shortly. And there is concurrently also a climate in which there are growing calls for drastic action in this area. And I am personally of the view that many of those calls are not only misplaced, but are positively dangerous. And I'll explain why. Already, there is a plethora of measures put in place by various legislatures. So you have, for example, what I think is the latest example of this in the form of an anti-hate speech bill, which I think has become law in Karnataka. I do not have either the expertise or the time to dissect that law. And in any case, what I'll try to do is not comment too much on Indian law, partly because I have actually been out of this country now for 4 decades, and partly also because a lot of what needs to be said about Indian law has already been said, particularly by the judge. But I want to actually enlarge the discussion slightly and talk in more general terms about the dangers that are attached to legislative, administrative, and dare I say, judicial measures that are intended to do something noble, but which may have wholly unintended adverse consequences. Now, I recognize that this topic has particular resonance in deeply divided societies, including societies like India. And therefore, I think there's a need for a better understanding of what we actually mean by hate speech, and therefore to address possible remedies. We should in particular avoid knee-jerk reactions. Now, you might find an incident which bothers you, which would be one of hate being mongered. That should not make you adopt a knee-jerk reaction and do something that will seriously harm the landscape of free speech. And there's also another aspect of this topic which I may not have the time to go deep into, but which I am very worried about, and that is what in shorthand is called the cancel culture. Now, you may not appreciate how corrosive that phenomenon is. In simple terms, cancel culture means you stop somebody from saying something that you don't like, instead of engaging with that person, if necessary, proving what that person is saying is wrong within legal limits, okay, not abuse. Let's have a civilized discussion. If you don't like what somebody is saying, debate with him or her and let the truth come out, let the better argument win. So the cancel culture is becoming a very big problem in many parts of the world. I'm happy to say that it hasn't caught on very much in India. It has to some extent, but unfortunately it's spreading like wildfire in my part of the world. The Western world is now deeply affected by the cancel culture. Anyway, let me begin a plunge into the topic itself. The first thing to say, of course, is that it is very difficult to define hate speech in precise legal terms. To a large extent, we all understand roughly what hate speech is, but even that understanding is not perfect. A lot of the time, people characterize speech that they find offensive, they find personally unacceptable as hate speech. I think that definition is too loose, and one needs to be very careful. But of course, hate speech can also come in very sophisticated ways. So it may not necessarily be a crude expression of hate. There can be a very sophisticated way of spreading hate speech, which we need to be aware of, and which therefore might need a legislative or administrative or judicial response. And of course, hate speech is not only speech in the form in which we normally understand it. In other words, a lecture or an abusive tweet. Display of certain symbols can also be hateful. That's another example. Also, the wearing of certain items of dress. You probably know the example from America of the Ku Klux Klan white robes. Now, those are the sort of things which can also create difficulties, or placing of certain objects in certain areas, in front of certain venues. A very common example with which all of you are aware is the placing of a pig's carcass in front of a mosque, or a cow's carcass in front of a temple, a Hindu temple. Then you have glorification of certain acts or events. A common example is glorification of the Holocaust, which would be considered deeply hateful by Jews. And then, of course, you have the public burning of certain objects, very common in certain countries. And there's a lot of jurisprudence, particularly from America, on the burning of the flag. So there are issues like that which also come under, broadly speaking, this topic. But I still maintain that defining hate speech is not easy, and that's why one needs to be very careful when one goes down the legislative route. Now, one central issue in all this is, should the mere causing of offense be made punishable? And my answer is an emphatic no. I am not arguing for the right to cause offense. Please don't misunderstand me. But I believe very strongly that simply because something causes offense to someone should not make it make that act punishable. Of course, you will immediately ask me, would you condone causing offense? And my answer is no. Because we all need to be very aware of our responsibilities. And this is a point which was made very eloquently by the judge. He used the terminology of obligations, fundamental duties, etc. I would say the same thing using a different phrase, which is ethics. So along with law should go ethics. So each one of us has an ethical duty to not engage in certain conduct, even if that conduct is allowed by the law, or to put it differently, is not prohibited by the law. We have a duty, and the ethical aspect, according to me, is to be emphasized, particularly in relation to hate speech. And there's also another advantage of adopting this line, which is that if you say that it is unethical to cause offense needlessly, and there is an exception I'll come to in a minute, then you're also sending a very good signal to society. And that signal is all of us need to behave ethically. And if we do, then the problem will be diminished in very significant volumes. Now, one way of encouraging that trend of behaving ethically is this tactic of naming and shaming. There are many countries where there is no law which prohibits somebody from saying or doing something, but there is a tremendous amount of shame attached to such conduct. And when that happens on a broad scale throughout society, it will take a long time in countries like India, but when it happens on a long scale, on a long volume, then automatically, maybe a generation or two down the line, will restrain itself from causing offense needlessly and gratuitously. So causing offense gratuitously is something I totally discourage. Now, are there occasions when it may be necessary to cause offense? My answer is yes. Now, that may come as a shock to you. Remember what I said at the beginning. I am not for causing offense willy-nilly or gratuitously. But I do believe that there may be occasions for reforming society when offense may be caused. Of course, the difficulty here is that the tolerance for offense varies from person to person. There are many people who take offense very quickly, even for very innocuous things. You offended me, so you should be punished, or you should be shut up. That's a very common argument used. I think that is completely wrong. But let me give you at least one example, because my time is short, of when it may be justified in causing offense. And I can give you many examples. I'm going to give you an example that is, I hope, not very controversial, not very provocative. And it is this. And I will try not to give you an Indian example. So, you know that until 2 years ago, it was an offense under Saudi Arabian law for women to drive motor vehicles, to drive cars. Simply because you're a woman, you cannot drive a car, full stop, okay? Now, there are many people who would disagree with that rule, with that law. Let us assume that there is a person who writes a very strong article condemning that law and that practice. Obviously, the mullahs are going to be very offended. My God, this is an insult to our society, our religion, our ethics, our culture, etc. But would such offense be necessarily bad enough to be prohibited? I don't think so, because how will society reform if you don't have people being shaken out of their complacency? So for a very limited number of purposes, I think we should leave room for the causing of offense. But normally we should not cause offense. I keep repeating that so that I'm not misunderstood. I'm sorry to say that in many societies, speech is being banned or punished simply because somebody takes offense. So that is a point which needs to be very carefully borne in mind. And then I come to the other central argument, which is that, which is actually something which has been referred to previously anyway, and that is the importance of the harm principle. So my thesis is this: you should only prohibit or punish speech that has a tendency to cause serious and identifiable harm. Not some vague kind of harm in somebody's head. It has to be serious harm. And there are already in my submission provisions in the law, including Indian law, which make such acts an offense for which you can be punished. If you did something causing alarm and despondency, many laws which do actually allow any speech or act that causes harm to be punished. And I think that is the import of the cases that the judge referred to, including the Kaushal Kishore case. My worry with the causing offense kind of standard is that it is a slippery slope, and we should not have slippery slopes in either constitutional law or administrative law. And therefore, one needs to be very, very careful to avoid those kinds of actions. So incitement to violence is something that should be the touchstone on which speech should be allowed or not allowed. Now, I immediately concede that it is easier for me to state that principle than to apply it in practice. The reason being that there is a broad spectrum of speech that can fall on one side or the other of that dividing line of whether harm is caused or not. So let me try in the very little time available to me to give you a flavor of the problem. It is this: suppose there's an epidemic of, and again I'm using very, very mild examples, an epidemic of cybercrime. Okay, I'm not using other types of crime, cybercrime. And you know cybercrimes happen a lot even in India. Now, if it turns out that there is evidence that a majority of those crimes are committed by a certain group within the population, and therefore there is public resentment against that group, public anger, public upset, etc. So if somebody writes an article in which they simply express their concern that a majority of these crimes are being committed by a particular community or a particular group in the population, would that be hate speech? In my view, no. But let's assume that there is statistical evidence received after credible research that 63% of all cybercrimes are committed by that particular group. And this evidence comes from respectable, credible sources. There's another article by someone else which says that in view of the evidence, the government should do something and we should have policies which will have to target those groups. committing these crimes. Is that hate speech? In my view, no, because that is also meant to reform the situation. There is more growing concern that the number of crimes increase, and then somebody writes an article in much stronger terms saying, you know, we are all sick and tired of inaction by the government against this particular group who we are convinced is causing havoc in society. It is about time that the government became firm and taught these groups a lesson. Remember the phrase, taught these groups a lesson. Is that hate speech? I would say that is bordering on hate speech. It comes closer to the dividing line. And then finally, there might be a politician, particularly just before election time, who goes on a public platform and says, you know what? All of us, responsible, law-abiding people, should do everything that we can, personally, to combat any member of that group. Okay? Again, not saying go and kill them, but combat, or words to that effect. Is that hate speech? I would say that is probably hate speech, which will have to be dealt with. First of all, by the law enforcement agencies in society. You don't, as a knee-jerk reaction, draft a drastic law which kills legitimate speech. But you have to start acting, because that is worrisome. Tomorrow it can spill over into unacceptable speech. So all I'm trying to tell you is what I've given you now is an oversimplified argument. The real argument will probably have to be addressed in 60 minutes or 80 minutes or whatever. I'm just giving you a simplified account of my approach to the harm principle. And I'm taking into account also the difficulties in defining hate speech. So even with the examples I've given you, it may not be easy. I'm nearly coming to the end of my talk. I'll just wind up by saying one or two more things. And I want to go to a point that the judge made, which was to do with marginalization, lack of dignity, etc. Again, I want to emphasize, I am not in favor of marginalizing any group in society. I am not in favor of assaulting the dignity of any group in society willy-nilly. But as I said, there may be occasions when I may say something or write something which some people will consider to be an affront to their dignity. Now, depending on whether what I say is reasonable or not, I should be allowed to say it, but with an important caveat. And the caveat is, others should be allowed to challenge me. That is the way we would advance freedom and democracy. Because if somebody challenges me, I'll become even more aware of my responsibility to defend what I've said reasonably. And again, I go back to the point I made earlier about naming and shaming. If it turns out that I wrote an article which is so indefensible, I deserve to be named and shamed in society as a fellow who is just a rabble-rouser. He has no real intellect, or perhaps he doesn't even have a stake in reforming society. So that is the kind of thing I think it is probably useful to know. There's one other point I would like to make before I sit down, which is in relation to the media. Now, as you know, media perform a very important role in all free societies, whether it's a democracy or not. And sometimes media are made the target of unjust, hastily prepared legislation. In other words, you are doing what has sometimes been described as shooting the messenger, which is also, I think, dangerous, because if you do not have a free and fair media, both words are important, then you can kiss goodbye to freedom and democracy. Media should be allowed, for example, to report a speech that may be uncomfortable to many people on grounds of hate or whatever. But of course, media have to be responsible as well. So I would say there are certain occasions when media will have to paraphrase what a particularly provocative politician has said. But at the same time, informing the public, the audience, that something of this nature has been said, which is not healthy for our society. So that is a point which I will not emphasize too strongly. It is something we have to remember. Please don't tar all media outlets with the same brush. There are some irresponsible media in any society. I completely agree. And I'm sorry to say that a lot of so-called television debates in this country are so bad in quality that you want to strangle the people who are running these programs. But please don't, of course, take the law into your own hands. One last point before I finally wind up is the importance for judiciary. You cannot buck that point. Look, at the end of the day, any dispute, absolutely any dispute, if it remains unsolved, will have to go to the judiciary. I'm not in favor of cases going to the judiciary, particularly in a country like India, where it can take 30 years for a civil suit to be decided. But you can't help it. Like you cannot have vigilante justice, so it will have to go to the judiciary. If you don't have a competent, well-resourced, non-corrupt judiciary, again, you can kiss goodbye to any concept of democracy or rule of law, etc. You can have a wonderful constitution, but if the judiciary doesn't deliver, as I said, there is no hope at all. I'm sorry to end on this rather negative or gloomy picture, but media, judiciary, very important. There is so much more I would have liked to say, but I'm very conscious of the lack of time. I'll therefore stop here, but I hope that we'll have a few questions in which I might be able to expand on some of my views. So thank you very much for listening patiently to me.
Thank you, sir, for that enlightening and thought-provoking address. We'll have a short audience speaker interaction now. Anyone with?
Sir, the Honorable Judge has observed that in view of the provisions contained in Article 19(2) of the Constitution, the restrictions, there are limitations for the restrictions. Now you said that it is desirable and it should be possible and to regulate the hate speech. As far as India is concerned, the learned judge has referred certain judgments of the apex court. So we are not in a position to go beyond because it's a constitutional court judgment. Is there any law in place in Northern Ireland or UK or other Western countries which regulate hate speech and defines it precisely? That is my question, sir.
Okay. It's a very important question and one which I'm happy to give what I hope is a reasonable answer. So first of all, of course, remember that the UK has a legal system which is rather unique, partly because we don't have a fully written constitution. So India is in a different position. There's a Bill of Rights. UK doesn't have that, but I have to qualify that immediately by saying we've had a substitute for a written constitution, not a wholly written constitution, but a substitute for a Bill of Rights, which is the European Convention on Human Rights, which has now become domestic law. So we have a law called the Human Rights Act, which requires all judges at all levels, even if it's at the level of the magistrate, to take into account the jurisprudence of Strasbourg, that is the Court of Human Rights. Now, I personally have a lot of criticism on that point, but I'm not going to bore you with that. I'll answer your question directly. You see, the standard that is normally used in, first of all, fortunately, there are not many laws banning hate speech, either in Northern Ireland or in Scotland or in England. They made attempts actually in Scotland as well as Ireland, not Northern Ireland, Ireland, which is a foreign country. But both those attempts came to naught because they were seen to be incompatible with freedom. But the short answer to your question is this. The standard that is used by the UK judiciary, actually we don't have a UK judiciary as such. We have 3 separate judiciaries, England and Wales, Scotland and Northern Ireland. They're actually disconnected. What the judges do is apply, in simple terms, 3 principles. One is the principle of necessity, the second is the principle of proportionality, and the third is the principle of legality. So in other words, if somebody wants to impose a restriction, typically the government, the judges will ask the question, first of all, is it legal? In other words, where is the source of law for this? You can't just have an executive fiat. Secondly, is the restriction necessary? Now that's a difficult question to answer because that is context dependent. And there are very fine arguments made. And luckily nowadays you get some of these arguments on YouTube. So if you're interested, do go to many of these arguments, particularly in our Supreme Court. And the third question that you asked is the restriction proportional to the ill that is sought to be remedied? So I hope I've not given you a too long answer, but there we are. Thank you.
Hello, sir. My name is Uttara. When you mentioned that the only aspect condonable for offensive speech could possibly be the reformative aspect of that speech, I do wonder if that's not the biggest slippery slope. It's a slightly long question, apologies in advance, for this particular reason. In a nation as diverse as mine, each community attacks the other community's speech on this very fundamental issue, what they believe bona fidely and vehemently to be a reformative aspect. Now, I do understand that one way to reconcile that would be through the reasonable man standard, but then I also wonder, oftentimes the reasonable man standards in a society are not of the highest reformative standard. The perfect example would be the debate an atheist, scientifically logical man would have with a religious person who's not a fanatic. They would be advancing their own interests, but the standard where reasonable man would hold would be slightly lower on the spectrum of reformation. So wouldn't that, how do we reconcile? That is my question.
Okay, so working backwards, the answer I would give to the last part of your question is that this is where the role of the judiciary comes in. Because no matter how carefully you draft a law, the law cannot be ultra prescriptive. The law cannot take into account every single occasion that is likely to arise for the application of a law, interpretation of a law. So I would maintain, I'm old-fashioned enough in that respect, that the reasonable person standard is still very useful. It's still fit for purpose. It has to be modified according to circumstances. And there is a very big problem that arises, which unfortunately I don't have the time to go into. I've delivered lectures on this point in many countries, and that is this. What happens when fundamental rights clash with each other? It's a very big problem. It's not as simple as saying one should yield to the other. So I'll leave that there. But in simple terms, that would be the approach I take. I want to also go back to something you made at the beginning of your intervention, which is this. It is not only the reformative aspect that needs to be taken into account in discussing these things. There are other aspects as well. One that comes to mind immediately is the educative aspect. That is extremely important. In any society, particularly if you're going to look at the solution I have proposed of ethics, of an ethical approach to some of these difficult issues, then two things have to go hand in hand. Education, by which I don't mean formal education only. education which should be more broad-based than that, including education in the home, what parents teach their children, etc. And secondly, also persuasion. So these two things are very important, and those societies which put a lot of emphasis on these are very successful societies. A country that I go to very frequently is Japan. And Japan is one of the few countries in the world, one of the few advanced countries in the world that does not have a national law on hate speech at all. Absolutely not. And Japan is one of the most peaceful countries in the world because there the ethical aspect is drilled into everybody right from the time they are able to respond, 3 years, 2 years, whatever, and it almost goes into their blood. So I'm sorry if I sound a little naive, I do apologize, but I still think that is a better way than to go down the slippery slope of getting more and more legislation which can be misused and which of course also clog up the courts.
Hello, sir. I think the drift of your argument was that one should counter hate speech by a way of more speech, that there must be a conversations. But I think that's impractical because we are all living in in the age of social media. We are all living in kind of an echo chamber. So if I can make a counterpoint, that legal censorship is necessary, especially in the case of social media, because in the social media sphere, what you said may be true in the sense of conventional conversation, but at least in the area of social media, nobody is conversing with each other. They are all in their own echo chambers, talking to each other, talking the same, spreading the hate towards each other. So in the context of social media, don't you think at least a much more effective legal legislation is necessary?
The short answer is no, but there's a longer answer. And it is this. Please sit down. It is this, that I want to make a fundamental point which should be obvious to all of you, which is that, because you're all lawyers, that the medium is only relevant up to a point in making laws, the content of laws. Defamation is defamation, whether it's done via a newspaper or in an electronic medium. Of course, there will have to be variations made in procedural terms, because social media are very different from what may be called traditional media. So that's a fundamental point I want to make. But also, I still believe that overkill in this area, and I think with some hesitation I will venture to give you an Indian example, Section 66A of the Information Technology Act, which fortunately was struck down. Now that is a very good example of overkill. It may have been done with good intention. Look, whenever I criticize anything, I'm not alleging bad faith on the part of either the legislator or the policymaker. I'm simply telling you that there are unintended consequences which it is necessary to avoid as far as possible. Sometimes you cannot avoid it. And I go back to the very simple point I'm making, namely responsibility. Why do you have to put out a tweet that is abusive when you can make the same point in a calmer or sober way? That is personal responsibility. We can all do it. Look, you may be very angry with something that somebody has said about you, but that doesn't give you the right to lash out left, right and center. So I'm afraid I don't agree with you, but which is not to say that either what you're saying is wrong or that you don't have a right to say what you're saying.
Any other questions?
You must ask a few questions of the judge. Because he's actually made a very thoughtful speech. I'm not saying this to flatter him, but genuinely the content of his speech as well deserves a lot of attention.
So greetings to the honorable personalities on the dais. So my question will be to the Justice. So how can we draw a thin line, or how can we dissect hate from criticism? I guess we Indians are a bit more sensitive to criticisms and consider it rather as a hate. So how can we draw a thin line, or how can we dissect criticism from hate?
I was actually going to point that out even before you asked that question, as a continuation of what Dr. Iyer was saying. You see, my take on this is this. How do you identify something as hateful? You must understand that we're talking about a country which is a very pluralistic society. You have people of every size, shape and hue, and different temperaments as well. When you talk about fundamental rights in our country and under our constitution, fundamental rights are first and foremost individual rights. The entire focus of our constitution, the entire focus of part 3 of our constitution is on the individual. It's not on a class, it's not on the nation as a whole. It's on the individual. And that aspect was made clear long time ago in the shift from the silos theory of Gopalan in 1950 to 1970 R.C. Cooper. So ever since, we've recognized fundamental rights as individual rights. We also recognize that whenever there is an infringement of a fundamental right, the test to see whether there has been an infringement is by looking at the effect of the action, state action, on the individual. Now, keeping that in mind, what is hate speech? Is it something that seems offensive to the whole of India, to a substantial part of India, of the population of India? Or is it something that seems offensive to the person at whom it is directed? So, something may not be hateful to the rest of the world or the rest of the country, but it may be hateful to me because of qualities that I have and that I possess, and things which are peculiar to my knowledge. And this is, it's not something that is confined, it's not a principle that's confined to law alone. It's what informs every aspect of education in humankind. Because what exactly is your knowledge? How do you get knowledge? It's by looking at things and your lived experiences. Your lived experiences is what allows you to have a perception, allows you to have an opinion. When I look at, I often give this example. So I hold up this card and I ask somebody, like, what color card is this? And a majority of you would say it's a red card. But suppose I ask somebody who's colorblind what card this is. He or she is going to say that this is black, because inherently they cannot see the color red. Now the question I ask is, who is right? Or more importantly, is somebody wrong? And the answer would be, nobody's wrong. But why is it that you see this as black? It's because of the conditions that I have, and it's because of who I am. My perception is shaped by my lived experiences, my physical attributes, etc. So it's the same with speech. The effect of speech is always perceived by an individual. And when you have that concept in mind, then the question is, in society, when do you say that a speech by somebody is hateful? Hateful to the extent that it has now got to be criminalized, or it has to be frowned upon by the society generally, or under the constitution. There, a multiple number of factors come in. Suppose we face this situation very often in court, when we deal with contempt of court cases. You have some person, suppose you have a madman coming into court and saying, your lordship's judgment is plain stupid. Is that defamatory? Is that something that I should, be so worried about? Because the world knows he's mad. The effect of that statement is not going to have a disastrous effect on the judicial institution. So, the person who says it, the personality of the person who's making that speech is one factor. The possibility or the probability of that person's speech influencing a substantial section of society to feel the same way as him is another. Which is why you have a segregation, which you have a distinction between cases where, say, a stand-up comedian is making a joke about somebody. He's a person who's famous, but he's famous for a different reason. He's famous for his comedy. If he makes a joke, even if it may be, within inverted commas, defamatory about something, you need to understand it in the context. And that's the key to realizing whether something is hate speech or something else. Hate speech, in my view, should be confined to those cases which are deliberately intended by persons of authority to create rifts in society, to create or incite violence in society in such a manner that it will affect a substantial portion of that society. That is hate speech. Because what is a crime? A crime has got a public element. Every crime is defined in public interest. It may be an offense against an individual, a person of a body, etc. But it is always in public interest. Is one person calling me an idiot, for example, is that hate speech? Well, between him and me, yes. But should it be hate speech for punishment? Should it be hate speech for preventing his fundamental right under the Constitution? I don't think so. So, it's not, you don't have a clear, solution for categorizing. It depends on a multiple number of factors. And they must all converge before it can be seen as being taken out of the ambit of a fundamental right. And that, I think, is something that we need to understand. And if you're looking for a key, if you're looking for a way out or a solution, in my humble opinion, the solution lies only in discussions, deliberations, so that you have a knowledge or a comprehension of the other perspective to a dialogue. And unless we start embracing that, unless we have the tolerance, unless we have the maturity to understand the other perspective, you're never going to have a solution for hate speech. That's my take on it.
Any other questions? Good evening. My question is to Justice. So, my question is an extension to her what she asked. So, based on what criteria or condition should a state should frame rules and regulation regarding this protection of speech, means regarding this hate speech and protected speech?
Again, I don't think the state should come up with a legislation precisely for that reason. Because you cannot, as my friend was saying here, you cannot conceive of all possible situations under which something may be categorized as hate speech. So it's always better to leave such things as open-ended. It's like your concept of, privacy. It's all good to read it into the constitutional idea of, freedom, right to personal liberty and right to life and personal liberty under Article 21. It's nice to trace that concept to that, but if you start going further and trying to find a definition, a legal definition, it's going to be difficult. So these concepts are best left open-ended, so that on a case-to-case basis you know. There are some things which you don't need to look into a book, you just know. And that's important in the case of fundamental rights because, as I said earlier, the infringement of a fundamental right is based on one's perception of whether it is affected or not. And that can vary from person to person. It's something like the effect of an accident on a particular person. Two people may not feel the same pain when they are subjected to an assault by a particular, like in your motor accidents case. So it's always better to leave these things as open-ended and decide them on a case-to-case basis, because generalizing it and making it a homogeneous class is neither desirable nor possible.
Just a very quick sentence or two. In addition to what the judges just said, you also have a very tangible standard on the basis of which to proceed, and that is the constitutional framework. Not just framework, but the constitutional provisions, the content of the constitution. What I am against is to read things into the constitution which were never intended and which could not by any reasonable standard be seen to be intended. And that is a worrying trend. And the point about legality was made by the judge very elaborately and extensively, that you can only impose restrictions on the grounds that are allowed by Article 19(2) in our context. There are other articles in the Constitution that talk about restrictions in other situations. So you cannot say, with good intention to say, affecting the dignity of somebody, let us impose restrictions. That is not permissible. That goes to the principle of legality, of the three principles I told you. So is it legal? According to the Constitution, it is not. And so you cannot apply it. But beyond that, you will have to give judges the discretion to deal with situations as they arise.
Good evening. My name is Binsal. Thank you, Mr. Justice Jayasankaran Nambiar and Dr. Iyer and other dignitaries on the stage for an intellectually vibrant evening. I have a question to Dr. Iyer. It's related to what you mentioned about cyber crimes. Please correct me if I misheard it or I got it wrong. I think you mentioned that 62% of the cyber crimes are committed by a particular group according to a particular authentic and credible study or report. Can you please elaborate on that aspect? Can you please reveal something more, which is that group and who made that study or report? And if it is highly sensitive, you may please give us some hints. We will find out ourselves.
My God, I have not made myself clear at all. This is a very serious failure on my part. You know what I was doing? I was taking a completely hypothetical example which had no basis in reality. And you know why I did that? Because I wanted to avoid slightly more controversial examples, of which there are many. I won't name them now, and particularly in India, it's a minefield. I won't go into that at all. I gave a completely hypothetical example. Please don't think of it as a real life example. Not at all. Absolutely not.
So I picked the mic to ensure that this will be the last question. It can be to both of you. Justice Nambiar said that it is necessary to have the assurance of excluding hate speech by ensuring constitutional morality in the mind of the speakers. And Dr. Iyer was also saying the best way to ensure that hate speech is responded to rightly is to ensure that there is naming and shaming of people who actually resort to it. My question is, what steps, solid steps we need to take to ensure that this spirit of constitutional morality is imbibed more deeper, and probably by that exercise increase the market for speech which is not hate speech. Nowadays there is more market for hate speech, and that is why there is hate speech, is what I usually, at least in the social media, etc. More likes, subscribe and shares happen because there is some element of hate in that speech. So how do we ensure that at least for the future we develop a society which is more ingrained in constitutional morality and which would actually name and shame people who resort to this? That, I think, should be the last question.
Well, let me answer that directly by saying encourage more public discussions and discourse. You see, we've all, anybody who's above 40 in this gathering would know that we all grew up in a society which was sans social media, sans television and other things which would distract us. The key to our maturity when it came to understanding things as not so serious, you knew to take a joke, you knew when to laugh, you had humor, even in courts. We don't find any of that happening today. Something that you say in lighter vein, you have to qualify it first by saying, this is in lighter vein, and then you proceed to say it. Why? Because it's perceived as something else the minute you say it. All this happens because of the disconnect that you have. There is no interpersonal relationship anymore. Please understand that you have social media, which is supposed to be connecting people, and you say social network. It is not. Social media today is a major disconnect. It disconnects persons from each other. Why am I saying this? There's a huge difference when two people talk in person and when two people talk or converse through social media. The absence of the other physically makes a big difference. Just look at it in terms of normal conversation. When you have a conversation with your friend on any topic, the emotional content is an integral aspect of that conversation. And the emotional content is expressed not only through through the words that you use, it is also through the tone, it is also through the body language, and a host of other things. That is completely taken away when you are conversing through social media or the internet. Which is why you find that notwithstanding the so-called connect, your friendships, the interconnect through the internet and social media, people are really lonely. The number of suicides in this generation is no longer funny. People are lonely, they don't have a shoulder to cry on, they don't have anybody to converse and talk about their difficulties, their personal problems, because their very introduction starts with deceit. Your profile picture doesn't resemble you at all. The advertisements that you see do not represent human beings anymore. Artificial intelligence has ensured, AI images have ensured that the most disgusting looking among us have the features of probably the most lovable soul or the most attractive person on earth. This is the world we're living in. It's a complete world of deceit. It's a complete world of make-believe. With what conviction are you going to confide in another person in that world? And therefore, if you want to bring back those times where people still enjoy a joke, people still find comfort in what other people are saying. He may, in college we've been called names by our friends. We didn't take it to heart because we knew the context in which it was said. We knew the intent with which it was said. And those are essential when you want to find out whether something is hate speech or something is harmful. And therefore, please come back to the real world, come back and have these personal discussions, because that is the essence of humanity. That is the essence of our ability to understand the other. And without understanding the other, you're never going to have peace in your life. You're never going to have peaceful coexistence in society. That's my...
Thank you, sir.
So in a word, education. It's a short way of summarizing what the judge has said, but I'll elaborate very slightly, and I hope this, because you said it's the last question, we can end on a positive note. Events like this, which are broadly put under the umbrella of continuing legal education, do serve a lot of purpose to a limited audience, and the audience here is basically members of the bar. I'm not saying that they need to have these things dinned into them, but it does make a difference. This is also part of overall education. And this extent, dare I say it, even to judges. So I actually do a lot of judicial training around the world, particularly Commonwealth countries. I immediately have to say that I've not done too many in India. I've done a few for what do they call state judicial academies. And I won't say anything more on that point, but I'll say something positive. So, you know, when you meet judges in a closed door environment, they behave very differently from when you meet them on a public platform, with a very clear caveat that doesn't apply to the person on my right, okay? I want to make that very clear. I'm not saying this again just to flatter him. The reality is, when you're in a closed environment, particularly if they're assured that whatever is discussed will be completely confidential, they are willing to listen. And I can tell you the kind of responses I've had, even within the very limited range of judges I have formally met for these sessions, is very heartwarming. Because what happens is, first of all, they're very willing to discuss complicated questions privately. And secondly, after the event is over, many of them, because we exchange email addresses, and they are in communication with a lot of judges at various levels of the Indian judiciary. And this is just India is one example. Actually, I do more outside India. And so that is, so for example, that should not be called CLE, it will be called CPD, continuing professional development, rather than continuing legal education, because judges don't like being told that they're being educated in that way. So you use different terms, you know, call it a workshop, whatever, but education is the only long-term solution, and it takes time. It may take a couple of generations before this concept of ethics, which I call obedience to the unenforceable, comes in.
Thank you so much.
I extend my special thanks to Senior Advocate Lakshmi Narayanan sir, Advocate M.R. Harraj sir, Senior Advocate, Advocate Uttara, Advocate Devika, Advocate Nancy, Advocate Binsal, and Rohit for making this interaction very grateful. Finally, I invite Advocate Rekha Vasudevan, Secretary, Samatha Law Society, to deliver the vote of thanks.
Good evening all. As we come to an end to this knowledgeful evening, I'm been bestowed with the duty, or rather an honor, to propose a vote of thanks as a Secretary of Samatha Law Society. The topic today was legal regulation of hate speech. Is it possible? Is it desirable? Many among you, just like me, would have come here prepared, unprepared, completely blank as to know what this subject is. Just like a student of law, our quest for knowledge is never ending. And today evening had been one of it where our quest had been again left open rather than to get more interested, rather being more interested into the subject. Coming to my duty, Justice A.K. Jayasankaran Nambiar sir had delivered introductory remarks on the subject. As I said, when I entered this room, I was as blank about the subject. No law has been laid down with regard to this subject. But the introductory remarks given by the Justice was enough to give us a picture as to what we are going to have this evening. Sir, from the deep bottom of my heart, as well as on behalf of those gathered here, we really thank you, sir, for giving us that insight on the subject. Then coming to our keynote addresser, Dr. Venkat Iyer, Barrister, Northern Ireland. Sir, it has been a great pleasure to have you among us, especially from Ireland, traveling all along from UK, or rather Northern Ireland, to the small state of Kerala and addressing such a small gathering. Though we have a large gathering online, but the interactions that you had with us, we are deeply, I express my deep gratitude for that, sir. I'll be failing in my duty if I be not thanking the Kerala High Court Association and also the office bearers for the same. The effort the moment that we approached them that we would like to have such a session in the High Court premises, the association with its all-hearted support came forward to help us to organize this program. Sir, Mr. President, Advocate P.S. Gautam, Vice President Vinay V, and also the other office bearers, especially the Secretary Nima, who is sitting behind as an audience, I express my thanks on behalf of Samatha Law Society for having us here. Sharing the knowledge with your own teacher is nothing less than an experience. Today we had Saroja Miss, who was my teacher in the Law College way back in 1994. She was here for some time. I thank her also for her graceful presence. And also our online viewers, because we had nearly 3,000 online viewers watching this program online, though we don't have much physical presence here. We thank them also for their graceful presence. Thank you.
Thank you all for being a part of this meaningful session. Have a great day.
We have tea arranged. Please don't leave. 1 second. Announce. I request the President of the Advocates Association to please do the honors with respect to the gifts to the dignitaries. First, to Justice Jayasankaran Nambiar, and also to Dr. Iyer. Thank you so much.
Thank you.
Right outside the exit door, tea is arranged. Nobody is permitted to leave without visiting that place, because otherwise the wastage will be too huge.